open our sessions in prayer and with the pledge. I'll lead us in prayer, and if Commissioner McCann, you will the pledges. So if you would. Our most gracious Heavenly Father, Lord, we thank you for this day. We thank you for those that are gathered here with us, Lord, and we ask that you be with us as we make these decisions for the good of our county and hopefully within your will. Father, we have so much to be thankful for, even in a year of 2020. And at the end of 2020 here, we give you praise for what has happened, that you have blessed us and brought us through this year. And Father, we ask that we be reminded and that you be with those that are not as fortunate as some of us in this holiday season. Father, be with them, bring comfort and healing, and we'll give you all the praise. In Christ Jesus' name we pray. Amen. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
All right. Well, thank y'all once again for being here. It is 1:02, so we will call this meeting of Commissioners Court to order. And everyone is present. Commissioner Tooley is joining us electronically. So we do have a quorum. And first item is citizens' comments. We have had 3 requests submitted, and each one of those wish to speak at the time that we actually bring up the matters. So we will move on to item 1, which is consider and take action on minutes from previously held meeting of Commissioners Court on December the 22nd, 2020. Are there any questions, comments, additions, or deletions?
Judge, if there's not any questions.
We approve the December 22nd Commissioners Court 2020 as presented.
I'll second his motion, Judge.
Motion made by Commissioner Tooley, second by Commissioner Thomas to approve the minutes as presented. All those in favor of the motion? Item passes unanimously. We are currently going to skip item 2. There's still some issues with the IT minutes that we need to iron out, so we're just going to pass over it and move on to item 3, which is consider and take action on Eustis ISD tax resale deed located in Precinct 2. Commissioner Tooley, would you like to speak to this item?
Yes, Judge. The Eustis School Board has set this up and has approved the tax resale lot for in Eustis ISD, and again, they're bringing it to us to approve approve this lot to tax resale.
Questions for the Commissioner? Hearing none, entertain a motion.
Hang on just a second. Judge, I move that we approve the Eustis ISD tax resale of a 1 acre in the J.P. Brown Survey Abstract 5 as presented.
I'll second that motion.
Motion made by Commissioner Tooley, second by Commissioner McCann to approve the Eustis ISD tax resale lot of 1 acre in the J.P. Brown Survey Abstract 5. All those in favor? Item passes unanimously. Item number 4, consider, discuss, and take action on boundary dispute issue with Kaufman County. And this is the time that we have had the individuals asked to speak, and please forgive me at the pronunciations of some of the names. The first one up is Greg L. Sermonar. Well, Mr. Sermonar, if you would, please come forward to the podium. And if you would, state your name and your address for the record. And then you'll have 3 minutes to speak.
Thank you very much. My name is Craig Sermonara. I live at 20040 State Highway 274 in Kemp, Texas. And we are part of this disputed, apparently, border area. And I believe, as of right now, all the information that I have is from the article that was in the paper and in the brief discussion with, it was Wendy and a neighbor and some information that I gathered from your secretary, I believe, was Judge. In any case, I have more questions than I have answers right now or even statements, but it sounds like this body is looking to defend the way things are now, which would certainly be mine and my wife's stance. That's the way we would like to see it kept. We want to make sure that as our representatives that you know how we feel about that, right? And there's a number of reasons, no reasons I don't know that are relevant, but if they are, I'm happy to talk about them. Otherwise, I'm here to let you know how we feel and that we will support you however we can. Since I don't have a lot of information, probably some of my questions you're going to answer through the course of this. And what I would rather do than talk about that now is I don't imagine this is going to get settled today. And so I can leave those remaining questions for another meeting, if that's fine with you folks, and spend the rest of the time just listening to what information you're going to put out today. Okay.
Thank you, sir.
Thank you.
Do you need the spelling? Would you mind spell your last name for her?
Just the last name?
Yes, sir.
CERMINARA.
Thank you, sir.
Thank you.
Next to speak that is requested is a Sandra and J.R. Key? Cahey. All right, if you would, please come forward. And again, for the record, state your name and your address.
And I left my husband at home. He thinks I'm at the grocery store.
Please, just state your name and address,
Sandra
please.
Cahey, 20072 State Highway 274. Yeah.
Okay, please proceed.
And I do not want to change from Henderson County. Our roads are a lot better than Kaufman's roads. Besides that, my house insurance goes way up in Kaufman County. I have to go to register my car. That also goes way up from what I pay in 7 Points. And we've lived there for 40 some odd years with no real problems at all being in Henderson versus Kaufman. The only time I had trouble with 911 was when I fell and broke my leg at my daughter's house, which is up the road from me in Kaufman County. Kaufman couldn't find her house. I'm on the highway. They found me very easily several times for my husband and different things. As far as the schools, we do pay Kaufman school tax. Our kids went to school there. But I think it's kind of neat that the forefathers back in the day juggled this and settled on a solution. It's worked fine. I do not want to change it. My husband doesn't want to change it either. And that's all I've got.
Thank you, ma'am.
Thank you.
And the next speaker that has requested is this Nagore?
Yeah, you got it right. I'm gonna pass. My husband already spoken. He said he has my same opinions.
All right. So you don't wish to speak at this time?
No.
Okay.
I rather keep it for myself.
All right. Well, thank you very much. I will go ahead and call the item up for discussion, and we have, as a part of this, our county attorney, Mr. Clint Davis. And as a recap, we received notice from Kaufman County on Monday, December the 21st, of a resolution that was passed on November the 24th that stated that, or that had been passed concerning the designation of the Henderson County, Kaufman County border. And I'll let Mr. Clint Davis take it from there.
Good evening, and I'm going to try and give you guys a lot of information this afternoon. You all know I have a tendency to talk very, very fast, and that's just one of my downsides, but I do want to try and give you some information. I think today's action item will be more of a discussion and less of an action. I will make some recommendations at the end that I think we should take action on. I will say first and foremost that this has the propensity to turn into a mess, or it's one of those issues in county government that's like Forrest Gump said, it's, that once you open that box of chocolates, you never know what you're going to get. And you'll see some of that as I raise issues that come up. I'm going to try not to disparage or talk about Kaufman County or what Kaufman County has done, but I will say right out front that I disagree with the way Kaufman County has gone about this. I do that professionally, in all deference and respect to them. I just think they got it wrong. I wish there had been more communication about this. Myself, Commissioner Thomas, the county judge, we met with them last on February the 7th of 2020. Shortly thereafter, as we all know, COVID broke out, and we've all been busy with COVID. We have heard nothing else from Kaufman County since that meeting on February 7th until this month when we received the resolution and the mail and the directive. I wish there had been more communication. I'm not going to try and pronounce his name, but I agree with the gentleman back here. Right now, because of the lack of communication, I have a lot more questions than I have answers. I've asked those questions to Kaufman County, and I'm waiting back to get some answers. My counterpart with the Kaufman County District Attorney's Office is on vacation until the 4th, and she may be the one to give us those answers. But I'm like you, like the public. I have a lot of questions that I don't know the answers to today. But if you have questions, ask. If it's not one I'm already trying to find the answer out, I'll try and answer it the best you can, or put it on my list. The dispute, it is, and Commissioner Cates said back in November when they passed this is a very long historical dispute between Kaufman and Henderson County. This is not a new dispute. I've been in office for 12 years, and it's come up about every 4 years, every time we have a turnover in commissioners over there. In 1890, both counties, Kaufman and Henderson County, went through the legal process of resolving this dispute, which involves hiring joint surveyors to go out and survey the line. There were some changes made in 1891, I believe, to it. So that just goes to show you that this has been out there for 130 years in the making. Bring us through to date. Again, we've had some meetings. We talked about it in February, and then we get the letter and the resolution from Kaufman County just a week or so ago saying that they're changing what we've recognized for the last 130 years as being the county line. They did it by resolution, and the letter directs certain offices of ours, our elections administrator, our appraisal district, to make certain changes, which again, when I say that I think Kaufman County did it wrong, I just do not think that this can be done unilaterally by resolution of a commissioner's court. There's a process in the government code that I will talk about that lays out how you resolve these disputes. And it's not unilateral action without the agreement of both parties. We are talking about a 1,200-foot notch. GLO, the General Land Office, and I'm sorry if I use acronyms, I'm referring when I say the GLO to the General Land Office. They recognize straight lines on Texas counties' east to west boundaries, unless it follows a natural waterway, which our east and west boundaries do on the NACHIS, or I guess I should say north and south boundary lines or straight lines. Our map for the last 130 years has had a notch in it. You can go to our appraisal district's map, that's what we follow. You can go today to the Kaufman County's appraisal district maps, that's what they follow. You can go to the General Land Office of Texas maps today, and the General Land Office of Texas recognizes the notch in the boundaries as it has existed for 130 years. Let me talk a little bit about the law. The Government Code has a chapter in it dedicated to boundary disputes, and it's Chapter 72 of the Texas Local Government Code. And the process is that either county may elect to initiate a survey of its county line. Upon doing so, we send notice to the other county, and at that time, they then hire their own surveyor to join in. It's not two separate surveys, but those two surveyors, one picked by us, one picked by Kaufman, would work together on forming a survey. The statute goes on to say that if the surveyors can't agree upon a county line, it goes to the GLO, and the GLO has surveyors that will actually step in to see if they can't, mend a resolution to the two surveyor conflicts. Once you have the surveyors all agreeing upon the survey of the boundary line, it then goes to the two courts. It would go to the Kaufman Commissioner's Court and the Henderson County Commissioner's Court. Neither court is required by statute to agree to a survey. If both commissioners' courts agree to the agreed upon survey, that survey is sent to the GLO, the General Land Office, and it's recognized and accepted by the state of Texas. Doesn't have to be, but typically it is. However, the GLO will tell you that the General Land Office does not set Texas boundaries. They do not have the authority to step into that process and declare this is the boundary or that is the boundary. They are going to first look at the surveyors and try and see if they can't come up with a survey. If in the event the counties cannot agree to a survey, then either county has the option to appeal that to a district court, and it's the district court of a neighboring county that joins both counties. That's carried on like a regular lawsuit. The statute actually says the lawsuit is conducted in the same manner that any other civil suit would be conducted. The district judge can hear evidence on it, can look at historical precedents, which again, I think that's in our favor. The fact that we've had a 130-year history of the boundary line today being there, it matches the GLO maps. People's deed and property records have been filed in those for so many years. The statute goes on, and I had made a note of this because I thought it was interesting, that the district judge determines. A minute ago I told you that the General Land Office, the commissioner, does not determine county boundaries. What it says is the district judge determines where the boundary is. That is a quote from the statute. And may enter a judgment that orders the boundary to be marked and resurveyed if necessary. So the district judge is not even constrained by the survey that's agreed upon. The district judge has the authority by statute to go outside of that and determine where the boundary is. Just making sure I'm not leaving anything else out. So. On the issue as it is today, and now I'll get into some of the problems. I've kind of laid out briefly the process or the procedure that I think you would have to follow to do that. Well, before I get to the issues, I've not talked to any surveyors. To my knowledge, I don't think the judge has or any of you on estimate. Commissioner Cates has thrown out there, that's the Kaufman County Commissioner, he has thrown out that the surveyors would have estimated, and I know this is a loose estimation on his part, $100,000. But remember, you're not just paying one surveyor. They hire one, we hire one, and they work together. So, you could be talking about several $100,000. Some have asked, well, gosh, we're talking about 700-acre notch. How can it cost that much to survey out a 700-acre notch? And Judge, I don't know if you have the ability to show the commissioners the original map of the Kaufman County line.
I do.
If we do, I will show you. The reason that it would cost so much to have a survey done,
Pull this back just a moment here.
and go over to the Chandler side if you get that map pulled up.
If you would give me just.
And if you can't, that's okay. I can just
I
talk
can't.
about it and do
I
my
can't.
best to describe the visual to the commissioner.
Sorry. Stop sharing. Is that now? A window.
Would the district judge order each county to have a surveyor if it got to that point? Or would he say one surveyor? Is that a?
And if you would, Judge, I'll come back to that. Just
Okay,
go
okay.
east to the Chandler line over on the Neches River. To answer Commissioner Thomas's question about whether or not a district judge would order the surveyors, no. What the statute says is either county can initiate the surveying process, which means we would, if we were us initiating it, we would hire a survey. We would actually set a date that our survey is going to begin. We send notice to Kaufman County, and then the statute says their representative surveyor shall be present on the date that our surveyor will start and assist. And then it goes on to say that if they fail to elect their own surveyor or do not choose to, then it's whatever our surveyor says. Obviously, conversely, I'm not playing it from our side. If Kaufman County wanted to initiate a surveyor, they would have to send us notice that here's our surveyor. We're going to begin on this date resurveying the boundary line. And if you guys want to have a surveyor there, you have them there. If we failed to do that, then it would just be whatever their surveyor said.
I got you. Thank you.
So what the judge has pulled up is the statute on the creation of Henderson County says, talks about the Anderson County boundary down there. And then it talks about thence up the Neches River. So we're coming north, from south to north, up the Neches River to the southeast corner of the A. Sidney Johnson's 1,280-acre survey, which you can see there on the map. There is the A. Sidney Johnson survey. And then it says that it proceeds, lost my place. Thence west to the Trinity River. That is all we have to go by. Now you get over into, and when he gets to the point, so you can see we head west in a straight line. And this is the original map. And then we hit the John Baker survey. Now you see those two I call them creeks, some might say rivers, but that is Caney Creek and the other little fork, Lacey's Fork. Those two now come together right where Cedar Creek Lake exists today. Obviously, Cedar Creek Lake didn't exist in 1850 when this map was made. And you see that John Baker survey. The John Baker survey, a lot of the historical documents have that entire abstract in Kaufman County. So one of the problems with Kaufman County's resolution is it goes back and it says that, again, with no field notes in the resolution, no descriptions, it says that they have resolved that they're going to use the GLO maps and field notes. Well, first problem with that is the GLO maps show our version, the current maps show our version of what we think the property line is or the boundary line is. So that's one problem, is now it's kind of up in the air as to which is it. Field notes then raises the issue. If we accept that there's no notch and that it's in a straight line, you now have to determine where that straight line falls from Mr. Johnson's survey on the Neches River straight due west. Here's where the mess comes in, is that line may be off in any given direction. That's also why where I got started off on this tangent was the cost. Why surveyors are going to charge you $100,000 is somebody has to determine where that straight line is today. It could not only affect our boundary line, we could end up affecting Van Zandt County's boundary line. And instead of talking 200 or 300 peoples, it's been estimated that this would affect 200 or 300 parcels or 200 to 300 households. You may increase that. We don't know where until a surveyor goes out. The Baker survey, there are a lot of the historical field notes and records that put it all in Kaufman County, which means on what we call the notch, where Kaufman County just kind of assumes for purposes of their resolution that it is the northern straight line for that notch, it may end up being the southern line of that notch and not the northern line of that notch. Let me continue before I make a conclusion on that statement. So that's one issue, is even if we accept there is no notch and that it's a straight line, there is a big issue of where that straight line is. I have a folder of deed records from the 1800s that are all handwritten. And you can imagine how they are worded and how they go, and they reference the hitching post and the tree and, so-and-so Smith's place down the road and all of that. There is no way without hiring a surveyor that a commissioner or myself, heck, I own 4 acres in Crossroads, and if I took my fences down and you handed me my field notes, I can't go out there and mark my 4 acres, much less the entire northern boundary of Kaufman and Henderson County. So one big issue is, even if we acknowledge there is no notch, somebody has to determine where that straight line is. Other issues that have been created by doing this through resolution rather than going the government code route is tax issues. I've asked this question to Kaufman County. Obviously, they're moving people's county of residence from Kaufman County and putting them into Henderson County, effective January 1st, 2021. Is Kaufman County going to collect taxes on those people who it says are not and have never been in their county? We can't tax them for last year's taxes. We didn't send out notice, and we maintain they're not in our county. We can't collect taxes. Do those people get a free pass on taxes this year? Their own attorneys, I have an opinion from their own attorneys that say they can't collect taxes from these people if they don't live in their county. So now we've created a tax issue with the 200 or 300 people that live in that area of how do we handle the tax issues? Again, he's instructed his appraisal district to remove them from their tax rolls. I don't know what that does for these people. Voter registration in the people that are affected by that move. He's instructed his voters registration office to remove them from the Kaufman County voter rolls. If we don't accept their unilateral proposed changes, then these people have no county of residence to register to vote. I don't know how you resolve that. And again, these are just some of the questions that I don't have answers to. Judge Richards instructed the sheriff that area is now in Henderson County. There goes their emergency service. You've got issues there. In essence, if all of that's the case, they've kind of created their own autonomous zone here in Henderson County that has no county of residence. Now, one thing I've asked all those questions from Kaufman County. I hope to get answers from Kaufman County on all of those issues. One thing that could be an answer to all of those is that they really aren't making those changes. I hope that is the answer to those, that they really aren't going through and making all of those changes, that they were hoping that we would come up with some agreement. Deed records. Myself and Commissioner Cates have had some exchanges on this. And again, he and I just respectfully disagree. I will stand here and say that I can almost guarantee everybody on this court and the other court that we are creating some title issues for some of the individuals out there. I can't tell you at what magnitude or what level that is. Maybe it's a $30 fix, maybe it's several $100s, maybe it's much, much more. but I can guarantee you we are creating title issues. Commissioner Cates, I will tell you, he disagrees with that. He says this is just a formality, that everybody that lives along a border, they have their deed records filed in both counties already, that it's, and I'm sorry folks, I'm just not buying that if I'm a Kaufman County resident and I have a title history of 130 years filed in Kaufman County deed records, and you all of a sudden, by unilateral action, make a move like this, that when I go to sell my piece of property, that I'm not going to have some sort of issues. Under the statute, when you have an agreement between the counties, those deed records are all transferred from that county clerk to our county clerk. We did this during the 12 years that I've been here. Maybe the only one on the court was Judge McKinney. We did this with Van Zandt County. Went very smoothly. Had an entire subdivision. And I even forget which way it went. But we transferred all of the deed records from one clerk to the other one. But again, when you have unilateral action and we're not in agreement, you don't have that. If you go the Chapter 72 route and you have litigation, you then have a judgment that will address the deed records. None of that's happened here. And they are again, when I say they, Commissioner Cates is very dismissive to that. And, you know, the only question that was asked during the Commissioners Court meeting where they approved the resolution was, I think it was Judge Richards that said, you know, what do the residents think about that? And Commissioner Cates responded and said, I don't know, I hadn't asked them. And he said, I don't think they're going to be very happy about it when they find out. Fundamentally, I'll say it again, I said it at the beginning, that is just wrong. That's just my personal opinion. That is just wrong. When you are affecting people's property rights, they have the ability or should have the ability to be involved and participate in that process. Where do we go from here? So I think you've got three options. One is, I guess we can accept Kaufman County's change and go ahead and instruct all of our offices to make these changes. I don't think that's a good idea. That's not what I would advise. Another issue that we have with the maps is, in addition to the notch, we have some parcels outside of that notch that clearly show to be in Henderson County that are paying Kaufman County taxes. We have properties that are clearly within Kaufman County that appear to be paying Henderson County taxes. And so I don't know how you resolve a lot of that without going through the survey. Again, most of that's probably just been adapted over years, but you've got some issues that won't even be resolved if you were to go along and move Kaufman counties. And so, you know, one thing that I would say is we've got to get this right. You know, if we're going to do it and make changes to a boundary line, we need to do it, and we need to do it right, and we need to follow what the law says. So I don't really see option number one viable, but that's y'all's decision. Option number two is we could move forward with the local government code, Chapter 7.2. We go ahead, we appoint a surveyor. We set a start date that our surveyor will do that, and we send notice to Kaufman County to have their surveyor go out there and let's survey that. You guys know the cost involved with that, and like I said, it's I don't know what you're going to get into when you try surveying a 180-year-old boundary line using 1800s survey technology, and you're applying 2021 survey technology to that. We may see a lot of changes come out of that. The third option is to us not to do anything. I don't see any danger with the GLO changing their map based on what Kaufman County does. GLO is very unequivocal about the fact that they do not change boundaries, they do not create boundaries. There's a process. The GLO will actually tell you if they have counties that come and ask them, they will tell them, start the survey process, go get surveyors and send us copies of the surveyors, and then we'll look at it and try and resolve it. So I don't think there's anything from our standpoint that keeps us from moving along and doing nothing, just as we have the last 130 years. The losers in that scenario are the people in the notch that are affected, the people that no longer have emergency service, or the people that no longer have a county residence for voter registration, or, and again, maybe they'll be all thrilled to death because nobody's going to be collecting property taxes from them. The last option that I would throw out there, and I would recommend that we do this regardless of what action we take going forward, is I think we go ahead and hire outside counsel to prepare. Because again, if this process continues, you will have surveying costs from competing surveys, and then I would foresee it ending up in district court litigation. Originally, when I was talking to their attorneys, we always thought that Van Zandt County would be the jurisdiction for that suit. I'm not so sure anymore. I think there's a chance that the statute goes on to say that if any other neighboring county's boundary could also be affected by the changes, it has to go to the next county, which would probably leave us Navarro County or Ellis County. It has to be a county that borders the two counties in dispute, which would put us in Navarro County District Court or Ellis County District Court. Regardless of which of these options, I would advise that the court go ahead and retain outside counsel. Flowers Davis is who we've usually used in the past for that. Retain the Flowers Davis firm. Let them look at it. Let them give you an opinion. Some have asked about whether to protect those citizens that are in the notch that could be affected by that. Would the statute allow us to go ahead and file some preemptive declaratory judgment or temporary injunction action against Kaufman County to enjoin them from making these changes without going through the statute? That may be an option, but that's probably something for Flowers Davis to advise you on. The other thing there is, it's kind of an odd situation. Do we, as Henderson County, remember the people being affected aren't even our residents, they're Kaufman County residents. Do we spend money getting a temporary injunction to restrain their county from doing something that's harming them, or do we simply say that, hey, that's Kaufman County's issue? Like I said, I don't know. That's something else we can look at going forward. I will say that I do have a lot of questions out for Kaufman County. I hope that I will hear something from Kaufman County. Again, we've not had any answers to these questions. I have asked, I've even gotten some responses. I hope they have some answers that will resolve some of my concerns about how they've gone about to do that. I just don't have that yet. And again, going back to what I said at the beginning, I really wish there had been more communication between February and December of dropping this resolution on us, and I think it would have avoided a lot of these questions that we have that we really don't have answers to now. What questions do you guys have?
Well, of course, I was at the meeting. Thought it was further back than February. And again, the meeting was very good. We had a good relationship. We had a good communication. We talked about it. Thought we'd continue. I was really shocked when the letter came in. So in my eyes, the questions are like yours. I mean, we got to have some answers, or we can't proceed too far. I'd like to know what did go on. For us to get the letter here at the end of the year, I think they met in November, and we got the letter in the middle of December. I'm going out of office. I came into office in 13, 14, 15, 16. The commissioner in Kaufman County and I talked about some things over there on County Line Road. We didn't have any issues. We talked about helping each other, and I told him I'd be glad to help him anyway. On roads now, we're talking about that road. I was out in Commissioner of 17, and then I came back in the middle of 18. So 18, 19, 20, it's come up again. It came up while I was not in office again, I think, with Commissioner Hayes. But again, the questions that I have are like you. To get it right, I think it's going to have a survey. I'm like you. I got some property I couldn't find the boundaries for nothing without somebody helping me. So a survey is what it's going to take.
And that's probably a very good reason. Commissioner Cates has been very critical of our body of government, not anybody individually necessarily, but our body of government for not taking action on this sooner. You know, he has made the statement that we all known about this for years, and you've sat on it and done it. And you know, he recognizes that he's going out of office, and this was a campaign commitment that he had made, and so he wanted to take care of it as a campaign commitment. But you know, here's what I would say in response to that. Is anytime you have that scenario, there's probably a very good reason that government hasn't gotten involved in the last 130 years with this. Because when government goes in monkeying with stuff that they probably have no business monkeying it with, what you end up with is a great big mess. That's just, again, Clint's personal opinion. The other thing that I'll say, you see me reading from a document, in case any of you are wondering about Clint's law. This is not something that I came up with. This is actually a 13-page opinion from the Bickerstaff Law Firm, which is a bigger Dallas firm, that actually wrote it to Judge Gent to Kaufman County. I'm reading the legal opinion that they got from their own attorneys telling them that they think joint surveyors should be appointed and that they should go through the Chapter Local Government Code, Chapter 72, and do the joint survey. So if you know, any of you are wondering, we know because we have a copy of what their own attorneys have told them they should do, and they just didn't follow it, which again goes back to, I think they got it wrong here.
Commissioner Tooley?
Well, some of the questions I have, I watched the Commissioner's Court for Kaufman County, and Commissioner Cates said that there was an owner that would donate land for a county road, and if that agreement was approved, it would be in, that property and that road would be in Henderson County. I guess we would be talking about the John Baker abstract.
Being in Kaufman County.
Looking at the GLO maps, it references that notch. And so then, if it references that notch, who named the road, County Road 4044? And when you get to the end of the notch, at the curve down toward the lake, the road changes to Dogwood Trail or Dogwood Drive, and also changes to County Road 2106. I don't know when the GLO maps were updated, but I was talking to somebody the other day, and being a former CAD operator, you just don't take a notch out of something of a straight line. Some instrument has dropped that line down, say 1,200 foot, and then run for, I think Clint said 1,200 to 1,300 feet. Google Maps says that it's County Road 4044. Other instruments I've seen on a website called Acreage Land, I believe, stated that it was a County Road 4044. Commissioner Cates also stated that the only impact would be, it would not impact people's mailing address. It would not impact their school district that they would go in. And it would only affect that people would be getting a cheaper tax rate and moving from a high Kaufman County tax rate to a low Henderson County tax rate. So, you know, I'm just trying to figure out where's the instrument. If it was a Denny's agreement, was it ever followed? I don't know if the volume 54, page 296 in the Kaufman County records is what they're talking about, but that gentleman says that that road that was approved that they talked about was filed in Kaufman County. And it says that this road should be used, or this property should be used for horses, cattle, buggies, carriages, any transportation in that was filed. So, you know, and like Clint said, we're talking about 130 years of a controversy, and I still do not believe, having been in a real estate and deed from my former job that both the deeds along a county is filed in 2 different places. I just don't, you're either in or you're either out. And can you tell me what GLO 54,650, 55,903, and 55,977 represent from the GLO pollution for Kaufman County?
Not off the top of my head, if I were to look at it. And what are those GLO references to? I can tell you about the deed where it's highly hypothesized that where the notch came from, and you're correct. That came from a deed from a J.W. Wood. Remember, the controversy between the 2 counties where it came up and they hired joint surveyors was 1890. Well, then the following year, a gentleman by the name of J.W. Wood turned around. He wanted all of his land in Kaufman County, and so he deeded the southern part of his property to Kaufman County in exchange for allowing Kaufman County to build what is known as County Line Road. That is where your notch comes from, is that 1891 deed. That's also, when I say this goes back 130 years, that's the benchmark that I've used for that 130 years, is that 1891 deed that created this notch.
And that's volume 54, page 296.
Correct, yes.
And that court that we've all been issued, and if you'll read it, it states what I said a while ago about the horses, the carriages, the cattle, or anything, and that's where the man filed in Kaufman County, and we have no record in Henderson County of that action being taken in 1891.
That's correct, which I think what you're getting at is that that's a pretty good indication that if that's the portion of the road today, and he filed that and granted it to Kaufman County, that it must have been in Kaufman County.
Absolutely. And Commissioner Cates also states at an hour and 38 minutes and 42 seconds of their commissioner's court that there's a dispute. We don't have a problem with the line. They're the ones that have the problem with the line. And there's something in the GLO office that's missing, because nobody as a draftsman or a CAD operator drop a line down and cut out like this notch is, and it goes due south, due east and west, and then goes back up to the north to proceed across 274. So I don't know if I'm ready to hire a surveyor and spend the money there, or hire I don't know if we'd be wasting money to hire a counsel to discuss our issue, or that we really don't have an issue, the issue with there. And furthermore, some counties that border us, and preferably Kaufman County, need to understand that because they have a resolution that they filed in their county is not going to take Henderson County's not going to jump up on January the 2nd or the 4th when we come back and just say we're going to change all this over. Their resolution can't bound us to the Commissioner's Court, so that's kind of other thing that I'm pretty perturbed about with Judge Richards.
Well, and we wouldn't...
Telling us that our sheriff and everybody else has to go over there also.
And we've not been provided, he said he directs our elections administrator to make changes in our appraisal district. They didn't provide a list with the resolution. They didn't identify parcels. I mean, like I said, we've got different parcels that are taxed by different entities on the line itself, but we have none of that from Kaufman County. So I don't even know that our elections administrator or appraisal district right now would even be able to begin making any changes.
Ms. Hernandez, you're on. Would you like to speak to that right quick?
I can, sir.
Okay, real quick if you could in a situation like this.
Sure. Whenever we have annexations and de-annexations of any municipalities or school districts, the one thing we require a map. Now, what is house 1 and house 50 on this road is in this district. And so from that point, we added 2 of their municipalities. We didn't receive anything but this letter of the resolution.
It's not sufficient information or sufficient? Okay.
So your process would be time consuming.
Oh, most definitely, you're on your own, and so.
It's not something we can do between here and January the 4th.
Yeah, I mean, there's not any kind of information, and that's even in the redistricting. You need a road, I need to know the house numbers on the road, what side of the road, and what school district, and municipalities, the districts are within those boundaries.
Okay.
So, yeah.
Thank you, ma'am. Thank you. Commissioner?
Well, I think our best option right now is to follow Clint's advice and hire outside counsel. And my opinion would be that we need to see if we could file an injunction on them doing anything that they stated they would do in that resolution. Because my worry is, I mean, and just like most of these people are not in Henderson County, so they're really not our worries anyway, but it's still going to leave that area in limbo. Now, these people who spoke today seem to be in that portion of property that is clearly in Kaufman County, but they pay Henderson County taxes. So it changes a little bit for where I'm looking it up, where their property is. But I mean, I don't understand how they thought after 130 years that they could pass a resolution and that we would just take it up, just like our elections chairman said today. It's time consuming. It's not something you just do between the time we got the letter a week and a half ago to January the 4th. And why they thought they could do this through a resolution and not going through the government code. I mean, it doesn't matter what we do here, that we're going to have to follow the government code.
I agree.
I mean, we can't just go up there and say, okay, we're going to take this little piece from y'all since y'all want to give it away. And it may change we're talking about 200 or 300 parcels. I mean, when you start drawing lines from the Natchez River to the Trinity River in a straight line, it may change thousands. I mean, in 1891 or 1846, whenever they formed Henderson County, they were pulling chains through the woods, through the trees, across Kickapoo Creek, across everything else. I mean, now they're going to use a laser. It could change everything.
That's exactly right.
I mean, I agree with I agree with the county attorney. This could turn into I mean, not only did they just think it was just a resolution, but this could turn into a mess.
Commissioner Tooley, you
And
have,
also, this resolution was signed on 11/24/2022, and it didn't reach our judge's office until almost 3 to 4 weeks later, which would be almost 30 days. So they've had it in their hands for 3 to 4 weeks, and then they want us to jump through hoops to take this over. So that's another issue that I have also.
Commissioner Richardson.
Yeah, I was looking back at some of the old surveys, just like the John Baker survey. That was a league of land, was 4,605 acres, I think. And it looks to me like I think that was petitioned in 1838. And I think when Texas when Henderson County became a county from the Nacogdoches district, probably when they got to that part, John Baker survey, he didn't want his league of land divided, and it looks like they just went around that. And that's the only reason I see it. And like I say, and if any of that has to be divided, then you got to start changing abstract numbers for surveys and all that. All the deed records and stuff would have to be changed. So, like I say, I think we need to go out for legal counsel myself and find out what's the best way to resolve this, but it does need to be resolved. We don't want to sit here 130 years from now, not us, but our ancestors, dealing with the same thing again.
Right.
To address, Commissioner Tooley had some concerns about legal fees. What I will say with that is I did reach out to Flowers Davis Law Firm just to make sure they had no conflicts in representing us in litigation with Kaufman County, because they do represent a fair number of counties, and they did not feel that there was any conflicts there. But I don't think right now this is going to be anything that we're going to spend very much money on outside counsel fees. But I do think it's something that we at least bring them in the loop. We get them up to speed on the potential out there, and we just kind of have them sitting there waiting. You know, they do not charge us a retainer fee or anything like that to be retained. It would just be money spent on the hours that they work, which right now, I don't think there's a lot to do. It's just something that I would think you guys would want them ready in case they do have to come in and we end up in district court.
Well, most of y'all know my opinion on this. As long as I've been with the county, this has popped up from time to time, starting back in the 90s, which I've informed everyone of. And the information that we've dug through, there are several renditions of Henderson County's boundaries when you look through the historical records. There's actually one that was done in 1846 and then was actually approved in 1861 that speaks to the Kaufman County basically entering Henderson County at Cedar Creek, following Cedar Creek down to Twin Creek, and then turning west to the Trinity River. Well, basically that takes 7 Points, Gun Barrel, and almost Toole out of Henderson County. That was the original incarnation. And then the 1879 language that Clint read here gave the description going from the Johnston property west across Van Zandt, all of Van Zandt County, and then all of Kaufman County to the Trinity River. And that line runs right at the border of the John Baker abstract that is specifically shown in the 1877 map to be completely in Kaufman County. The county attorney stated that in the late 1880s, early 1890s, there was a dispute that counties hired the surveyors. And I'm assuming that it was through this effort, we're assuming it was through that effort that revealed this particular, the notch as we call it. It's very interesting that prior to 2006, it was very quiet. There was joint operations between Henderson County and Kaufman County on County Road 4044. I was fortunate enough to be actually working on the road crew then and working with them at that time. Commissioner Jerry Brewer was the commissioner of Precinct 4, Kaufman County, and Harold Hammer, which was my predecessor as commissioner of Precinct 2 in Henderson County, worked together on that road, and Kaufman County took care of half of it and Henderson County took care of the other portion of it. The road is the minor issue in this. It is all of the individuals' property. It's individuals that, you know, for some reason have a restriction to live in Kaufman County that might live in that particular area. Having the assistance of legal counsel, I truly believe we need in this, because as also county attorney mentioned, those individuals that currently live within the notch, if Kaufman County moves forward, they're pretty much in a no man's land at that point.
There's, without knowing who's out there, I mean, what about other issues that we haven't even thought of? What if you have residency requirements for your employment, like we all do, that say you have to live in a certain county? And then all of a sudden, you know, you go to sleep on December 31st living in Kaufman County, and you wake up on January 1st living in Henderson County. And you've had all of 10 days notice of the change coming up. I mean, and again, that may be far-fetched, and we all may say, oh, the likelihood of somebody living in that 700 acres is unlikely. But those are the things that in my 12 years of experience as government that tend to come back and bite you the hardest, is the ones you think will never happen. I mean, I wouldn't really think we'd be here in 2020 debating about the boundary line between two counties in Texas. I would have thought that would have been worked out before now.
I do as well. There are other items that I could point out, how Kaufman County approved its official roadmap in 2007, May of 2007, which was under Chapter 258, I think, that allowed counties to recognize an interest in their roads. Well, incidentally, at that time, the disagreement started between then Commissioner Jim Deller and Commissioner Joe Hall of Henderson County. And in that process, 4044 was left off of the creation of that map. But yet 4045, which is latitudinally just across 274, equal with 4044, is on the road map. So I'm thinking that some issues, as the county attorney mentioned, small minor issues that left to fester and to mistakes made over the years have long-lasting effects. And that's what I think we're into now. So I really would like to have us gain that representation, because we don't know what is going to happen. You could have individuals living in the notch that, if their title is clouded, could, take all of us to court, both counties to court. So I think we need to be prepared and very vigilant, because any changes in the line would not only affect Kaufman and Henderson County, it would affect Van Zandt County as well, which affects Precinct 3. So, any other comments or discussion?
Do we need to make a motion?
We do need a motion granting authority to engage Flowers and Davis as outside representation.
I'll make that motion.
And I'll second his motion, Judge.
You got it, Mary Margaret? All right. Motion made by Commissioner McCam, second by Commissioner Thomas, to engage Flowers and Davis Law Firm to represent Henderson County as outside counsel for the matter of this boundary dispute. All those in favor? Item passes unanimously. Thank you very, very much.
We didn't do anything on the injunction to keep them from changing anything.
I believe in that. The question is should any injunction be sought immediately, or
I think
what's our
that's
step?
discussions that we'll need to have with Flowers and Davis, and again, let them look at some of the historical documents. I don't think they've been sent anything or know anything. Let them look at it, and then that may be something that we would want to end up having an executive session to have our counsel come back and advise us on what they feel the appropriate next steps might be.
One of the things that does concern me that when we do have is that we'll need to start taking steps for procurement of finding a surveyor, just in case we have to have it in our hip pocket. So, anything else before we move on? All right. Item 5 is receive financial reports, and we have none of those. Item 6 is consider and take action on payroll disbursements and accounts cash sheets, and we have none of those. Item 7 is consider and take action on submitted contracts. I don't believe we have any. Item 8, consider and take action on requests for right-of-way permits, and there are none. Oh, we do have Google Contracts. It is not linked in here on my... Gentlemen, do you? Okay. Mr. Josh Brock, our IT director, if you would come up and present.
I'm thankful that that's not skipped over, because we are basically facing the deadline of January 1st. And the reason we've basically come to the wire on that is because of the COVID situation. We've been in negotiations with them since probably March of this year. What we're looking at doing with the increase of smartphones and the county employees, every one of them needing some kind of connectivity back to the county, what we're using is Google or G Suite to host our email, our Drive, Google Drive, So anything that we share between each other, it's all based through our government contract with SADA, which is the reseller for Google. That's who provides us the contract. So what we're looking at doing is providing enough emails for everybody in the county. We hadn't done that before. We'd actually shot for an amount for enough because detention officers, some of the road crew, some of the maintenance staff, they didn't necessarily need email addresses. Why that's become crucial is because of our employee portal, which of course gives them access to get paper, I'm grasping here for a moment, get documents that they would need to file with HR or insurance. So to give that to them securely at home, the best way to do that is to provide them some kind of email address through our Google services. So what we're looking at doing is adding 25 of the G Suite business accounts. We had 325. We're looking to up that to 350. And then we're looking to add 150 what they call deskless, which is it's not as robust of an account. It's actually more of kind of just an email address, an email account that they can use. And then we're looking at adding 50 of the archive users, which basically gives us ability that if a user were to leave and we need to retain their box, that we wouldn't have to add that on to tack it onto the end and add a 501, 502. We can actually put them in an archive, go back and browse the account. If there's some issue that we need the account to stay open for a while, that's what the archive would do for us. That's going to just be a one-year contract. So this is for 1 year term. There's some changes that they've made us aware of. We're not sure of all the changes that they're looking at. They're not necessarily sure of it because they're kind of in their development phase on that. So we're catching them at a cusp of a change. So what we're looking at doing is increasing technically 150 boxes and then adding 50 archive boxes. I'm sorry, that is incorrect. 175 boxes and then adding 50 archive boxes. And that's going to make the total 41,340. What we're asking today is so that the contract can be signed so that we can continue our service with Google.
This is as Mr. Brock said, an increase of 200 boxes, 200 users?
It's
roughly?
actually 175. We have
175
325 right now, but the 50 is archived.
Right, and due to the fact of our HR department communicates 80% of the time in this fashion, having that provision available for our employees, not to mention the increase in software as a service that we have our employees having to have credentials, even at the Road and Bridge precincts, using PubWorks, having that. It's a growth, a growth factor. Yes, and one of the things I have, even 5 years ago when we originally did this contract, I called the individual a crack dealer then because they were giving us the product so cheap. It was 10,000. What?
Basically 10,000 a year.
10,000 a year. 10,
For 325.
Right, for 325, and this takes us up to 41,000. Not only did we increase the number of boxes, but also the rate has gone up. We believe that there is enough funding available within the IT department to get us through this first year. Is that correct?
I believe so.
That we should be able to withstand it under current budgeting, but especially during the time of COVID, and with everyone that's on the screen, this is a part of our operations now. It's not the only operation. That's why this is a one-year contract, and we hope to look for leverage in the future to either bring their price down or move to another product, is my hope.
That's correct. And to just to add to that, this number was not something we just said, okay, thank you for that. We did negotiate over and over. We pushed back. We even told them that we couldn't accept the price that they offered us initially. So they did, I think it was 30, I'm gonna say 35%. It's around that number. 35% discounts what they came up with, which was a lot more than what they were proposing at the beginning. So basically say $6 a box per month. We were looking at closer to 10 when we first started this negotiation. So we did get quite a bit of discount. The option that we had, really the only option that we had, was to look at Texas Association of Counties had negotiated with Microsoft 365 to go to their product. at $10.25 a box. So we're actually coming in even considerably lower than that, of course. They were neck and neck as far as price. Moving forward, and at the end of next year, when we're looking at this contract again, we're going to be looking at that number, unless we can negotiate the price again. So I'm hoping that we can, of course, use every wrench that we can throw in the cogs to say, we want this product at the discounted rate that we're currently getting it at, but just be prepared that probably not going to get this number again either. And that's just the way the whole software as a service and the hosting of this Amazon and Google and Microsoft, they have us all, and they get to take us down whatever path they want to take us down. We're trying to go kicking and screaming so that we can get as much discount as possible.
Questions?
I have a question. So when an employee leaves the county, is that a usable box again?
That is correct. That's what we have now, of course, but when we initially, we added, it's been 10 years. When we went to hosted email, I think we had 225 boxes, and we upped that to 325, and we thought that would be plenty. And I would say in the next 3 years, we wound up brimming at that point. We've been brimming at 325 for I don't say essential, they're essential employees. But for employees that don't need email, we've been brimming. We've always been brimming at 325 for the employees that needed email that was essential to their job. And then so when we started looking at the numbers again, we see it about, I think it was 425 basically now is what the number we're looking at. Mm-hmm. So we're giving a 75 user increase so that we don't have to just knock a user off to add another one on like we have been doing. To answer your question indirectly.
Is that sufficient, Commissioner Taylor?
Yes, sir.
Okay. Any other comments?
So you're saying 500 boxes?
500 total, that is correct.
And what is the 50?
The 50 is the archive. So what that'll do is allow us to leave a box in a dormant state and doesn't add on to the 500. So in case we do wind up using 450, 475 boxes total down the line, then we wouldn't be jockeying for the last 25. It's just an insurance policy, basically, to carry out any litigation or anything like that that a box is needed to be held on to for an indefinite amount of time. That's what the archive would do. I know it's just for the year, but we may have somebody happens right now that we need to hold the box, so we'd have it for the whole year.
Yeah. That has become more and more of an issue, is meeting the statutory requirements on retaining this electronic data. The issue we have now with texting has to be backed up through SMART. No different with this particular situation. Any further? If not, entertain a motion with the judge's authorization to sign.
I'll make the motion.
Second.
Second.
Motion made by Commissioner McCam, second by Commissioner Richardson, to approve the Google SATA contract with the county judge's authorization to sign. All those in favor? Item passes unanimously. Now on to number 8. Consider and take action on request for right-of-way permits. We have none. Number 9, consider and take action on submitted budget amendments, which we have none. Item 10, consider and take action on payment of bills, and we have none of those. 11, consider and take action on submitted plats. No plats. Item 12, open and consider bids, and we do have a late entry into this one.
I have received a few calls concerning the road materials bids. I've had a couple of vendors call. They have not received the information for the 2021 road materials bid and the packet information that was sent out on December 15th. I got to thinking about it later this morning, and with the issues that the United States Postal Service has been having right prior to Christmas, and still haven't quite figured out if they've gotten that straightened out. It would kind of make sense that some of those letters may not have been distributed completely to all of the vendors that we sent those notifications to. So I'm asking the court to extend that deadline and let me get that notification out to our vendors so that we can ensure that we get a good response back.
How long would you like?
That's up to the court. I can send email notifications to the vendors that we've gotten responses back from in the past. That does limit that notification to vendors that we may not have had bid previously, but I can put a notification in the paper and post it on the website as well that, that deadline has been, pushed out. With the issue with the Postal Service, I mean, I don't know how long it's going to take for those notifications to make it. I mean, it could be another week, it could be 2 weeks.
Well, in the past, when we have run long, and I remember specifically about 3 years ago, our bid ran long for a month and a half, I remember, right on road material. We even did a couple of rebids, may have been longer. The commissioners were still able to obtain material on the other one. It would not.
Right. We have a clause in all of our bids that allows for a month-to-month of continuation of awards. So any bid that we have awarded will continue on a 30-day renewal until the next bid cycle is awarded. So everything will continue on and stay. We shouldn't have any issues with you guys being able to get any materials or products or anything like that.
What was the date on the original?
2 o'clock, January 5th, which is a week from today.
Why don't we do 2 o'clock on the 19th?
Commissioner?
I'd like to ask Jennifer a question. Is all road material that we had in the 2020 on there?
Yes, sir.
So, because I believe that, did we bid sand and clay in a different bid?
No, sir.
We didn't bid underneath the road material?
It's all there, all oils, emulsions, road materials, it's all in one bid.
Okay, well, specifically sand and clay, is that on that bid? Because we bid it separately last year.
I'll have to double check on clay, but I know sand is.
Okay.
I don't
as
have-
long as, I'm okay as long as sand is in there. And I think the other commissioners will be too, but I thought that we bid that separately last year, or the first year, 2019.
We did. In 19 we did, and then we brought it together to a certain degree. We'll have to turn back and look, double check.
Okay.
So, Commissioner, you were.
The 19th?
2 weeks would be the 19th. That'd make, the mail should be there by then.
Anybody have any thoughts on that, the 19th? Commissioner Taylor?
I'm good, Judge.
Okay. Make that motion.
I'll make the motion, we change the bid date, due date to January the 19th at 2 p.m.
Second.
Motion made by Commissioner McCam, second by Commissioner Tooley, to extend the 2021 road material bid opening to January 19th at 2 p.m.
Yes, sir.
All those in favor of the motion? Item passes unanimously. Thank you very much.
Thank you.
And item 13 is consider and take action to adjourn.
I'd like to make that motion, Judge.
Your
Adjourn.
last motion of
Thank you.
your political career.
Thank you for letting me have that one.
Second.
Yeah, Tooley took my minutes away from it, so that's okay. That's all right.
Motion made by Commissioner Thomas, second by Commissioner Richardson, to adjourn the meeting for Commissioner Scotty Thomas's last time on Commissioner's Court. All those in favor of the motion?
Thank you, Cord, yeah.